Hey patent friends, I got a fun patent quiz for you, and it's not only enjoyable, but it's actually really important to understand the answer to this, and it can make the difference between getting your company off the ground, attracting investors, and causing real problems. That's something that I see with clients all the time. So here it is. So which of these is not a real patent asset? So the first one is a provisional patent, an international patent, a provisional design application, or is it all of the above? Okay, so take a second to pause the video, think it over, and actually write down in the comments what you think the answer is. Okay, I'll let you pause the video now. So before I give you the answer to the question, I want to stress how important it is to understand the concepts here. This is not just a fun patent quiz. It's actually something that I see trip up clients all the time, and I've seen them almost miss out on major deals. I've seen them lose deals with big investors as a result of some of these things. And I'm going to explain, one, what the answer is, but then two, how you can avoid these major pitfalls just by not knowing the answer to this simple quiz. So the answer actually is all of the above. None of these are actual patent assets. Okay, let's go through these three one by one, and I'll explain why these are not actual patent assets. These things do not exist, and why it's essential that you know this. Okay, let's start with provisional patent, the first one. Okay, there is no such thing as a provisional patent. Okay, I know that you see it all over the internet. People talk about provisional patents. There are even books that say provisional patents on them that I've seen recently. It's in media a lot, but there is no such thing as a provisional patent. What there is a provisional patent application. Okay, it is a provisional patent application, not a provisional patent. Now, what you're going to say now, Dylan, is like, okay, well, yeah, it's a provisional application that, you know, at some point will become a patent. Well, no, that's not true, and it's something that actually can slip people up and can cause big problems. And so let me give you some background. So a provisional patent application, it is just a placeholder. It only lasts for 1 year, and then it automatically expires at the end of that year. So a provisional application on its own will never become a patent. It cannot. It always expires at the end of 12 months, no matter what. But what you have to do then is you have to file a non-provisional patent application, and the non-provisional patent application will claim priority to that provisional. Again, you're going to say, well, Dylan, yeah, okay, it's a provisional application that, you know, then you claim priority at the non-provisional stage, so it's a provisional patent. What's the issue here? Okay, so, well, no, it's problematic still, and I've seen this trip clients up a lot, because what they say is, well, I have a provisional patent, and then it gets shortened to I have a patent, and they start telling this to investors, they start telling this to potential partners, they start using this on their website, and it's totally untrue, okay? It's something that, you know, ends up killing deals a lot of times. And here's a great example. I had a client who had been messaging their stuff saying, oh yeah, you know, we have a provisional patent, and then would sort of use the shorthand and say, well, we have a patent. And then their investor said, oh, this is awesome. We want to see your patents. We want to look at this. That's great. And they said, oh yeah, here is our patent. And it was a provisional application. It was really early stage. And the investor said, well, wait, what do you mean? This is a provisional patent application. And they said, oh, well, but I mean, what we meant was, it was a provisional patent that it's, you know, just, it's going, no, it's early stages. And then, well, you know, we still need to file the non-provisional, and, you know, and yeah, I know that that's going to take a long time. Like, well, but you initially said that you had a patent, right? And so in this case, they lost their deal because the investor was like, it doesn't seem like you understand what's going on. You don't understand the patent process, and I don't trust you. And sort of an analog to that is, you know, another client was in that similar situation. They were able to salvage the deal, but they had to backpedal and be like, well, okay, what we meant is we had a provisional application, and yeah, we understand that, you know, then you have to file the non-provisional, and then it can be years before that application actually issues into an enforceable patent, and that's actually when you have a patent. And they were able to convince the investors that, you know, they weren't trying to defraud them. But it's something that can cause real problems with folks. So here's what you have to understand. So again, provisional application, they only last for 1 year. Then you have to file the non-provisional patent application. Okay, the non-provisional patent application, you don't have a patent then either. You have a non-provisional patent application. You wait in line for 1 to 3 years before examination begins, and then during the examination process, you still don't have a patent. You still have a pending non-provisional patent application. This negotiation with the examiner, this can take sometimes months, if not years. You will get a notice of allowance if you've convinced the examiner that what you have is new and non-obvious over the prior art. And then you'll pay an issue fee, and then the application will grant as a patent. That is the only time when you can actually say that you have a patent. And people use the term patent inappropriately a lot, and it causes them a lot of problems. At the very least, it's something that could sort of tank deals and cause distrust with investors or other partners. At the worst, it could be perceived as fraud. So understand, there is no such thing as a provisional patent. Okay, now let's go over the second answer, which is international patent. Again, there is no such thing as an international patent. What people are typically talking about, or what they're trying to say when they say international patent, is a PCT application. So a PCT application itself can never mature into an issued patent. A PCT application allows you to then file national phase applications in any PCT member country, which is, it's almost every country in the world. So it's almost like a provisional patent application for filing patent applications in specific jurisdictions. So there's a lot of misconceptions here that are going on when people say international patent. So one is, so you can't have a patent in multiple jurisdictions. Patents are jurisdiction by jurisdiction, okay? So you can have a patent in the United States, you can have one in Japan, you can have one in Canada, and you have to file at these individual patent offices in order to get a patent in that specific country. There are some regional patent offices like the European Patent Office, but in the end, you still have to validate the granted patent in specific jurisdictions. So yes, there is a unified way to get examination that will then allow you to go into specific countries, but even then, like I said, you still have to pay money for a patent in each specific country in the European Union. So when people use the term international patent, again, it gets them into really hot water. They say, oh yeah, we have an international patent, when what they mean is we have a PCT application that gives us the ability to, at some point later on, file applications in specific jurisdictions. Investors say, oh, awesome, you're covered worldwide, and we can enforce against people worldwide. And then when they look into it, it's like, well, wait, no, like, so you have a pending patent application. You haven't filed any patent applications in any specific country. You haven't done any of that. None of these are issued and enforceable patents. What are you talking about? It comes off as like you don't know about that patent process, and it could come off as being fraudulent, that you're actually trying to oversell what you have. When it really comes down to it, it makes you look really bad in due diligence. So understand, there is no such thing as an international patent. There's just a PCT application which sets you up to file in specific countries. And then the third answer is provisional design application. And this is kind of a wrinkle of US patent law. Now, let me step back. There are two main types of patent applications in the United States. There are utility patent applications, and then there are design patent applications. Utility applications can cover wide varieties of things, and the way that the claims work in a utility application is with words. Okay, so they can cover designs in a lot of ways, just describing them in words. They can cover methods of doing things. They can cover manufacturing methods. Whereas design applications, they only protect one specific ornamental design of an article of manufacture. Now that's sort of a good way to think of it. It's sort of just the external structure of one specific single design. In design patent applications, it's the drawings that actually form the claim of what is protected. And again, with utility applications, it's going to be specific words that describe it. And so it can broadly cover a lot of variations. Designs only cover one specific ornamental design, and usually it's going to be sort of the external structure of something. Okay, so in the United States, you have a provisional application, which then allows you to file a non-provisional utility application 12 months later that claims prior to that provisional application. There is no analogous application to that for design patent application. So if you're going to file a design patent application, you have to file a non-provisional design application. You can't file a provisional application and then a non-provisional application like you can with utility applications. This one isn't quite as important. I haven't seen this one trip people up, but it is important if you want to protect designs, because what happens is that, so for instance, you file a provisional patent application, you start making public disclosures, public uses, and offers for sale of that design, you don't have an early prior date, and you could be forfeiting patent rights, because later on, if you want to protect that design, if it's been public disclosed, public use, or offered for sale, you may not be able to protect it because you forfeited patent rights. In the United States, you have 1 year to file that application, and in a lot of foreign jurisdictions, you automatically lose patent rights upon a first public disclosure, public use, or offer for sale. So some people think, well, hey, you know, I want to file a provisional application that's going to protect everything about this product. Some products you need to have only a design application, or you need to only have a utility application. Sometimes it's best to have both. You can have something that protects an ornamental design that a utility application wouldn't be able to cover because it has different standards. And people forget that, oh, you know, I need to file my design application first instead of filing a provisional application, which is the great way to start the utility patent process. So if you're getting some value out of this video, please give it a like. I would really appreciate it. It helps get the video out to more people. Also consider sharing it with some folks, maybe posting it on LinkedIn, and let me know down in the comments, what do you think about this? Was any of this surprising? Have you made this mistake? Do you know anybody else who's made the mistake of using these terms? And consider subscribing if you want more on patents, especially for inventors, entrepreneurs, and startups. And we will see you again in the next video. Thanks.